So for chapter 2, I will be discussing Article 1489, which talks about the capacity to enter into a contract of sale. Article 1489 states that all persons who are legally authorized to obligate themselves may enter into a contract of sale. This simply means that if a person has legal capacity, they are allowed to buy or sell. Legal capacity refers to the ability of a person to understand and enter into agreements. So generally, adults who are of sound of mind can freely enter into a contract of sale. However, the article also mentioned that this rule is subject to modifications in the following articles, meaning there are certain exemptions or special cases where some people are restricted from buying or selling. Now, the second part of Article 1489 focuses on minors or persons without legal capacity, such as those who cannot fully understand or legally consent to contract. As a general rule, these persons cannot validly enter into contracts, but there is an important exemptions when it comes to what the law calls necessities. Necessities refers to basic needs like food, clothing, shelter, and medical care, as mentioned in Article 290. If these accessories are sold and delivered to a minor or a person without capacity, the law says that they are still required to pay a reasonable price. This does not mean the agreed price will always be followed. Instead, the payment must only be fair and reasonable depending on the value of the goods or services. For example, imagine a minor buys a food from a store because they are hungry. Even if that does not have full legal capacity to enter into a contract, they are still required to pay for the food because it is a necessary. However, the seller can only charge a reasonable price, not an excessive or unfair amount. Another example is if a minor is given medical treatment. Even without full capacity, they are still responsible for paying a reasonable cost for that service. So Article 1489 establishes that only persons with legal capacity can enter into contract of sale, but it also protects sellers by ensuring that minors or incapacitated persons must still pay for necessaries as long as the price is reasonable.
Okay, so now let's talk about Article 1490. This article states that a husband and wife cannot sell property to each other. So even if they are legally married, they are not allowed to enter into sale between themselves. So the question is, why is this rule in place? First, to prevent fraud or cheating. The law wants to avoid situations where one spouse might use a sale just to escape responsibilities or obligations. Second, it is to avoid hiding of property. A spouse might try to transfer ownership to the other just to make it look like they no longer own it. So instead of being real sale, it becomes a way to hide assets. Third, it is to protect the both spouse from unfair advantages. In marriage, there can be influence or pressure. One spouse might agree to something that is not really fair. So even if the law prevents this by not allowing the sale at all. However, this rule is not absolute because there are exceptions. We have two exceptions. First exemption is whether separation of property agreed upon before marriage. This means that each spouse owns their property separately. Second exception is judicial separation of property. This happens when the court orders that the properties of the spouses should be separated. In these cases or situations, the husband and wife are allowed to sell property to each other because their assets are already legally separate. So in the summary of Article 1490, a husband and wife cannot sell property to each other to prevent fraud, hiding of asset, and unfair situation. But if their properties are legally separate, then the sale is allowed. That's all for Article 1490.
Next, we will discuss Article 1491 under the topic of capacity to buy and sell. According to Article 1491, there are some people who can buy a specific property because of their position that is connected to that property. The legal purpose behind this article and the reason for their prohibition is to prevent abuse of authority for personal gain, avoid conflict of interest, to maintain integrity and fairness, especially in some legal and public processes, and lastly, to protect trust in a fiduciary relationship. What is a fiduciary relationship? It is a relationship where a person is legally and ethically bound to act in the best interest of another. In simple terms, it is a relationship that has trust, confidence, and loyalty, and a person should act with honesty and in good faith. Based on the article, even though the property was available for sale in auction or done to another person, the following people are still prohibited to buy that specific property. In short, buying it indirectly is still not allowed. Buying it to another person means you are using a person to buy it for you. So take note that this is still prohibited to the law. This is important to avoid using a third person or a dummy just to bypass or defeat the purpose of law. Now, let's discuss the following persons who are prohibited. First is the guardian. They are prohibited to buy any property that is from the person they are taking care of, to avoid taking advantage of their power. In other words, they can use their relationship as a guardian to buy a specific property from the person that is under their guardianship. Let's say a guardian offers to buy land at a low price from a minor that is under his guardianship. This is not allowed because he used his power as a guardian to buy the land at a lower price. Second is agent. Agent is not allowed to buy property that they are handling for sale or management, unless the consent is given by the principal. For example, Gio, a real estate agent, is prohibited to secretly buy the property they are selling, to prevent manipulation of the price for the personal gain of the agent. However, if Sia, who is the principal or the owner of the property, let Gio buy it and give her consent, then that's the time when the sale is going to be valid. For the next one, we have the executors and administrators. They are also prohibited to buy the property they are managing because they must protect the property instead of benefiting from it. Let me give an example. An administrator bought the property he is managing from a deceased person. This is also not allowed because he should manage the estate for the heirs and creditors, not for his personal gain. Then we have public officers and employees, including judge and government experts, that are involved in the sale are not allowed to buy government property that they are handling or under their control. This is to maintain fairness and avoid having advantage of insider or misuse of authority. Next, we have persons in the administration of justice, like judge, prosecuting attorneys, clerks of superior and inferior courts, and other officers and employees connected with the administration of justice are prohibited to buy any property that is involved in an ongoing case under their jurisdiction, to avoid being biased and manipulated in a legal case. For example, a lawyer can't buy a land that is subject of a case he is handling, which means they can't let their personal interest conflict with their responsibilities in a case. Additionally, A sale will also be void if a person is prohibited to buy a specific property under the other specific laws. Take note that violating this article will result in a void sale or void ab initio. Void ab initio means the sale is void from the beginning. It cannot be ratified or be valid later, and it produces no rights or obligations. In conclusion, Article 1491 protects fairness, public trust, and prevents abuse in property transactions. That's all for the Article 1491. Thank you.
Now, let's talk about 1492. Article 1492 states that the prohibitions on the preceding laws are applicable to sales to legal redemption, compromises, or renunciation. At first, it may sound difficult because of the legal term used, but it is actually simple because the main purpose of 1492 it is to prevent people from avoiding the law by simply changing the form or label of a transaction. Let's take a look at this. A lawyer is prohibited to acquire a property on a certain case he or she handles. But later on, he compromise it between compromise it in a form of agreement to the person. So how does it work? Under 1490 and 1491, a lawyer is prohibited to acquire a land or any property under he or she case he handles. But if he do it under a compromise agreement, 1492 also prohibited this act. Why? Because under 1492, any property or on the prohibited person acquired under legal redemption, compromises, and renunciation are prohibited or as the law does not allow it. So what is legal redemption? First is the legal redemption is simply the power or given by the law to buy back or acquire a property under certain conditions. And the second is compromise. A dispute between two parties can be solved peacefully without continuing the case. That is compromise. It is simply solving or having an agreement despite having a dispute between two parties in order not to continue the case. And third is renunciation. Renunciation is simply giving up the power to a right to acquire property in favor of another person. So let's go back to the case we given. The lawyer is handling a case and wants to get the property under compromise agreement because the law under 1491 and 1490 does not allow him or she to acquire a property because it is a case he handles. So if we go to a compromise agreement, the law will not allow it, and the property will be still remain under the possession of an owner. So let's take a look at the example on our presentation. Some contracts that may look like a lease or a rent in simple terms, but it gives the buyer an option to buy. So under these certain conditions, it looks like a lease or a rent, but it gives an option to buy. So how does the law handle it if the buyer didn't pay at the right time and the property is taken back? Well, the law will solve it by providing stating it as the sales on installment, meaning to say the property will be given to the buyer because the law will acknowledge it as a sales on installment. So how does 1492 relate to this? Because 1492 is simply look at the true nature of the transaction, not only by its title or label. So, meaning to say, even if it's stated as a lease or rent, but it is an option to buy, the buyer may still acquire the property because the true nature of the transaction is an option to buy. So, meaning to say, will you give your money for simply a rent and be taken back, the property will be taken back because it is called a lease or a rent? No, right? So, in simple terms, to summarize, Article 1492 does not look at the label or the title of a contract or a transaction. It looks at beyond the true nature of its or the effects of its transaction. Any property any property acquired may be in legal redemption, compromises, or renunciation may still not be really literally acquired by a prohibited person because the law doesn't allow it. That's all, and thank you.
Next, I will be discussing Article 1493, which talks about what happens when the object of a contract of sale is already lost at the time the contract is perfected, or where it is only partially lost. To begin, Article 1493 explains two important situations. First, it states that if at the time the contract of sale is perfected, the object of the sale has already been entirely lost, the contract shall have no effect at all. When we say perfected, it means that both the buyer and the seller have already agreed on the object and the price, and the contract is already considered valid in form. However, if it turns out that the item being sold no longer exists at the exact moment, then the law says that there is no valid contract anymore, because you cannot sell something that is already completely gone. For example, imagine a seller agrees to sell a specific motorcycle to a buyer. However, unknown to both parties, the motorcycle was already destroyed in an accident before they finalized their agreement. In this case, even if they both agreed on the sale, the contract is void and has no effect because the object of the sale no longer exists. Now, the second part of Article 1493 deals with the different situations. It says that if the thing is only partially lost, the buyer or vendee has two choices. The buyer may either withdraw from the contract completely or continue with the contract, but only for the remaining part of the item and pay a price proportional to what is left. This means that the law gives flexibility to the buyer depending on what is more beneficial. For example, let's say a seller agrees to sell 10 sacks rice to a buyer, but before the contract is finalized, 4 sacks are damaged and can no longer be delivered. Now only 6 sacks remain. In this case, the buyer has two choices. First, the buyer can cancel the entire contract since the original agreement was for 10 sacks. Or second, the buyer can still proceed with the purchase but only for the 6 remaining sacks and only pay for what is delivered based on a proportionate price. So if the total agreed price was for 10, the buyer will only pay for 6 sacks accordingly. So Article 1493, it protects both parties by making sure that if the object of the sale is totally lost before the contract is completed, the contract is void. If it is only partially lost, the buyer is given the choice to either cancel the contract or continue with what remains, paying a fair and proportional price. This article is important because it ensures fairness and prevents either party from being forced into an unfair agreement when the object of the sale is no longer complete. So that concludes my discussion on Article 49.
Let us now discuss Article 14.9.4, which talks about the effect of partial loss or deterioration of specific goods before the ownership is transferred to the buyer. This article applies when the parties intended to sell specific goods already identified at the time of sale. So, specific goods are the items that were clearly determined and agreed upon by both parties when the contract was made. So, these are not just any goods of the same kind, but the exact goods chosen for the transaction. For example, if a buyer agrees to purchase 100 iPhone 15 stored in a specific stockroom of an electronics store, those units are considered specific goods because they have already been identified. So, before the ownership passes to the buyer, the goods may be affected in two ways. First is partial loss. This happens when only a part of the goods is lost, destroyed, or can no longer be delivered, while the rest still remains. So, for example, if 20 out of the 100 iPhones were stolen from the stockroom before delivery, that is partial loss because only some of the goods are missing. Second is fully or materially deteriorated. This means the goods still exist, but their condition has become seriously damaged, causing a substantial change in their quality or character. So, for example, if the remaining iPhones were damaged by floodwater and can no longer function properly, that is deterioration because the goods are still present, but they are no longer in the same condition as when the sale was agreed upon. Another requirement of Article 49.4 is that the seller must have been unaware of the loss or deterioration. This means that the seller did not know that the goods were already missing or damaged at the time of sale. So if the seller already knew about the problem and still continued the transaction without informing the buyer, the seller may become liable under the legal rules. And the purpose of this article is to protect the buyer. Since the goods are no longer complete or in their original condition, the buyer should not be forced to accept them under the same terms without having legal remedies. To continue Article 49.4, once the goods have been partially lost or materially deteriorated, before the ownership passes, the law gives the buyer the right to choose what to do next. So the first option is to rescind or cancel the sale. This means that the buyer may withdraw from the contract because the goods are no longer complete or are no longer in the same condition originally agreed upon. For example, if a buyer agreed to purchase 100 iPhone 15, but before the delivery some units were stolen while the others were damaged by water, the buyer may decide to cancel the sale because the original agreement can no longer be fully satisfied. The second option is to proceed with the sale for the remaining goods. This means that the buyer may still continue the transaction and accept the goods that are still available or still in usable condition. For example, if 80 units remain complete and functional, the buyer may choose to accept those units instead of canceling the entire contract. And the buyer can do this easily depends on whether the sale is divisible or indivisible. A divisible sale is the one where the goods can be separated into parts or units and each part can still be valued on its own. For example, sacks of rice, boxes of phones, bottles of water, or pieces of furniture sold in quantity. So in this situation, the buyer may accept the remaining portion and pay only the proportionate price. This means that the buyer pays only for what can still be delivered. For example, if the contract price for 100 phones is 1 million pesos and only 80 phones remains in good conditions, the buyer may accept the 80 phones and pay only the amount corresponding to those 80 units. On the other hand, an indivisible sale involves goods considered as a whole. This cannot be reasonably divided without affecting their value or intended use. Examples include a car, a machine, a generator, or a house. If part of that item is lost or seriously damaged, the buyer may cancel the sale because the object is no longer complete. For example, if a buyer agreed to purchase a specific car, but before delivery the engine was severely damaged, the buyer may rescind the sale. However, if the buyer still chooses to accept it, payment is generally based on the actual value of what remains after the damage. So to conclude, Article 1494 reflects the principle that a contract of sale must be based on the condition of the goods as expected by both parties. When unexpected loss or damage happens before ownership is transferred, the law allows a practical and equitable solution instead of forcing the parties to continue under unfair circumstances. It shows that the law values good faith, fairness, and the protection of both buyer and seller in the commercial transactions.